A Supreme Court special bench is set to hear a series of petitions challenging the constitutional validity of the Places of Worship Special Provisions Act 1991. Now, this law has prohibited so far filing lawsuits to reclaim and alter the character of places of worship as they stood on August 15, 1947. Matter will be heard by a three-judge bench comprising of Chief Justice Sanjeev Khanna, Justices Sanjay Kumar and K.V. Vishwanathan. Petitions challenging the act have criticized cut-off date of August 15, 1947. Here's a look at the provisions of the Places of Worship Special Provisions Act of 1991. It prohibits converting any place of worship. Again, mandates maintaining their religious character as it was on August 15, 1947. It also includes provisions to in fact address issues connected to or incidental to this very purpose. The Act again exempts Ayodhya's Sri Ram Janmabhoomi Tirth Kshetra. These are some of the major provisions within the Places of Worship Act that we are looking at. The hearing of the Supreme Court will begin in a little while on this very matter.
में उन स्थानों को रिस्टोर करने का अधिकार मिलना चाहिए और उसके लिए जरूरी है पहले सर्वे हो। कोई भी कानून लीगल रेमेडी नहीं छीनता। इवन वक्फ एक्ट में भी ये व्यवस्था दी है कि आप वक्फ बोर्ड के सामने जाओ। आर्बिट्रेशन एक्ट में कहता है पहले आर्बिट्रेशन करो, अगर फेल हो जाए तो कोर्ट जाओ। ये ऐसा कानून है, आर्बिट्रेशन की भी छूट नहीं देता, आपस में समझौता करने की भी छूट नहीं देता, कोर्ट जाने की छूट नहीं देता। कोई अलग से वक्फ बोर्ड या वक्फ ट्रिब्यूनल जैसा कोई बोर्ड नहीं बनाया कि जहां वहां जाके हम अपनी बात कह सके। तो ये कानून पूरी तरीके से राइट टू जस्टिस को रोकता है, इसलिए हमने कोर्ट में चैलेंज किया हुआ है। हमारा ये कहना है, अगर डेमोक्रेटिक कंट्री में विवाद का समाधान कोर्ट के जरिए नहीं होगा, यहाँ अराजकता फैल जाएगी, यहाँ भीड़ तंत्र हो जाएगा। अगर कोर्ट का दरवाजा बंद कर दिया गया, फिर तो अपने अपने स्थान के लिए लोग लड़ाई सड़कों पे करना शुरू कर देंगे, देश में अशांति फैल जाएगी। इसलिए जरूरी है इस कानून को खत्म किया जाए और हिंदुओं को भी, जैन को, बौद्ध को, सिख को अपने अपने स्थानों के लिए कोर्ट की लड़ाई करने की परमिशन दिया जाए, वहां का सर्वे कराया जाए। आज की डेट में बहुत लेटेस्ट टेक्नोलॉजी आ चुकी है, राडार टेक्नोलॉजी है, जीपीएस टेक्नोलॉजी है, कार्बन डेटिंग टेक्नोलॉजी है, ऐसे बहुत सारी टेक्नोलॉजी है जहां एक हफ्ते के अंदर पता किया जा सकता है कि जो स्ट्रक्चर है उसका फाउंडेशन कब बना, उसकी दीवार कब बनी, उसका गुंबद कब बना। फाउंडेशन गुंबद बदलने से मंदिर मस्जिद नहीं होता है, मस्जिद मंदिर नहीं होता है, उसके लिए तो बाकायदा सर्वे करना पड़ता है। इसलिए हमारा ये कहना है ये कानून खत्म होना चाहिए और सभी हिंदुओं को अपने पौराणिक स्थलों को रिस्टोर करने के लिए कोर्ट का दरवाजा खुलना चाहिए।
Well, ladies and gentlemen, that is what has been said. That is the very Hindu side with regards to this particular case that is to be heard by the SC's three-judge bench today. What we understand at this given point is the Hindu side has said that surveys should be allowed and Hindus should be allowed to understand where their heritage comes from, what their culture is, what history holds in terms of these places, and that is what they are fighting for in the court of law at this point. So, arguments of the Hindu side: the Act violates, the Places of Worship Act violates Article 25 and 26 of the Indian Constitution. That is the particular matter that's been brought up in front of the court, that there is a contradiction within the Constitution when we speak of these two particular articles. Article 25 and 26 guarantee the right to practice and propagate religion. And this act discriminates against Hindus, Jains, Buddhists and Sikhs. So this is the particular point that we are talking about. They have said that if there is a freedom to go ahead and practice your own religion, the Hindu side has put up this particular argument, then in those cases, they should get to know what the original state of that particular location was. Any given location, that is, any particular place of worship, that is, what was the original character of that place of worship? Was it the particular institution, or rather the building that stands there now, or was it different when it was first established? That is the Hindu side. Again, the Muslim side says that the act is preventing the reopening of historical wounds. They have time and again said that the act was a conscious decision by the parliament, which is why one needs to stick to it, else you will go around digging up various such places, at this point probably thousands of such places, to understand what the character of that very place was before 15th of August 1947. That is the particular date that we see in this Places of Worship Act. Now, the act is aimed to preserve the social fabric of the nation, which is why that date is taken into account, because if we try determining the history of each and every religious building out there, or for that matter religious body out there, a particular any particular religious building that we are speaking of, it could be a temple, it could be a church, it could be a particular mosque. But again, we've seen the temple mosque conflict more often here in the recent past. So if we try determining the original character of those places, then at this point no one knows how many such sites will actually be needed to be dug up to understand these characters. So these are the two sides that have been presented. These are the two sides that will be taken up, that will be rather heard by the Supreme Court, and we will keep a track of what the court, the apex court of the country, has to say on this very matter.